Hi, I'm Paul Ross with the Labor and Employment Department at McAfee Taft here in Oklahoma City, and it's been a busy spring for those of us that manage employment law compliance. I'm sure it's been busy for you as well, but it has been especially busy at the regulatory level. And today we have a very important new set of regulations that we want to discuss. The long-awaited updated regulations from the United States Department of Labor regarding eligibility for overtime. And so we're going to talk about three things this morning. We're going to talk about what has changed under the new DOL rules. Second, we're going to remind you about what hasn't changed and how important it is not to lose sight of the rest of the particular issues that show up in those regulations when we're talking about exemptions. And then we're going to talk about action steps for employers, what to do and what not to do in response to these new regulations. And so obviously DOL overtime regulations have been a hot topic for 3 consecutive presidential administrations. We've had updates to these very same DOL regulations from President Obama, from President Trump, and now from President Biden. And all of those changes to the overtime rules have had us kind of reeling from time to time. We've had to evaluate new rules, back up, evaluate new rules again, and here we are with a third set of rules to evaluate now from President Biden's administration. These particular rules were promised as soon as President Biden took office. We expected them to take a certain form. They really didn't. They kind of took a different form than we expected, and it took quite a bit of time, but those regulations are finally here. So before we talk about the regulations themselves and the changes that have come along with the new regulations, I think it's important to remind everyone of some of the core principles when it comes to overtime. And with me today is my friend and colleague, my partner here at McAfee Taft, Natalie Ramsey. And Natalie, if you don't mind, let's just start with the basics of overtime. What do employers need to know at core about overtime?
So as a general rule, overtime is pay that is required for employees who work more than 40 hours in a given work week, and they'll receive 1.5 times their regular rate of pay for any hours worked in excess of those 40 hours during a work week. Now, overtime is generally something that applies to what we consider to be blue-collar type workers, meaning those employees who perform manual labor. They're usually not and don't come within what we call the white-collar exemptions, which is what we're really here to talk about today. Those exemptions are generally the administrative, the executive, and the professional exemptions, and also outside sales and some computer professionals fall within those white-collar exemptions. Each of those categories have very detailed descriptions and definitions. It's a 3-part test. One is a duties test, and that's where we run into the very detailed analysis of whether or not a position falls into one of these categories. They have to be paid on a salary basis, and they can't be paid less than a minimum threshold. And as of today, that threshold is $684 a week or $35,568 a year.
Okay, so now that we've covered a little bit of the background and how things exist now, I think it's important that we kind of lead into what has changed. So as of April 23rd, 2024, we have the new rule. We know when it's going to take effect. It's going to take effect on July 1st of 2024, which is quicker than we expected. But we now know what changes are going to be a part of the new rules and what changes aren't going to be part of the new rules. So going back to the concept of what has changed, Natalie, what is the single thing, the most important thing that has changed with respect to that definition of white-collar exemptions that you just gave us?
So with these changes, their focus, the DOL's here, is the salary threshold. And it's how much we're actually paying those employees per week or on an annual basis. That is the big change for us. Currently, as I said, it's $684 a week. This is going to be staggered out, this introduction of change, in 2 phases. The first phase will be July 1 of 2024. And those exempt white-collar employees then will have to be paid $844 a week or $43,888 a year in order to enjoy that exemption from overtime.
Okay, so the change then is only to the minimum threshold. Was there any change at all to this idea of a salary basis?
No. So the way that you can pay an employee still remains the same. You must pay them on a salary basis with a few exceptions for instances in which you can pay on a fee basis, but those are largely the same. There hasn't been any modification of the actual mechanism or the structure of the pay. It's the threshold level that's been adjusted.
Okay. So I also understand that as a part of the new rules, the exemption for highly compensated employees has been changed. What's the new rule? What has changed with respect to highly compensated individuals?
So much like with the other salary basis threshold, we're going to see that change in two phases as well. The current amount that a highly compensated employee has to be paid under the DOL regs is $107,432 each year. And starting July 1, that's going to go up to $132,964 per year. And then we're going to see another shift or another change when we get to July 1 of 2025. That minimum is going to increase again to $151,164 per year.
Okay, so the theme here appears to me to be simply that the minimum thresholds for any white collar exemption are going up, and they're going up significantly.
That's correct. And it's also important to note that after this shift in 2025, when we hit this second phase, the thing that employers will also have to keep in mind is that under these regulations, every 3 years, there'll be another evaluation of these salary level thresholds, both for the regular white collar exemptions and the highly compensated. And we'll see these numbers potentially adjust upward every 3 years.
And so the changes then under these rules seem to be fairly limited. Not that they're not impactful, they're very impactful in the sense that they've gone up significantly with respect to those dollar amounts, but the changes seem to be very limited. So we're still under a situation where blue collar workers almost all the time are going to be non-exempt and they're going to be eligible for overtime. That hasn't changed. It is still the case that white collar employees can be exempt, but only if they meet the job duties test, they're paid on a salary basis, and they're paid at the new thresholds that will go into effect July 1st, and then again on January 1st, and then again every 3 years thereafter. But importantly, nothing has changed with respect to the job duties tests. So Natalie mentioned at the beginning of the presentation that job duties tests are complicated. They're long, they have a number of definitions, and so what is still going to be the case is that employers have to make sure that if they're going to classify an individual as exempt, they're not only looking at how they pay them, they're not only looking at how much they pay them, but they're also looking at whether their primary job duties actually meet these long and complicated tests. So for example, when we talk about the administrative professionals exemption, one of the white collar exemptions, that definition has at least 7 different concepts in it that all have their own long, complicated definitions. And so it's important to point out that the duties test still exists, it has not changed, and it is still a critical part of determining whether you're classifying employees properly when you're making them exempt or non-exempt. And so this is a good time, don't you think, Natalie, to not only evaluate your employees in how they're paid and how much they're paid, but to make sure that you're classifying those employees correctly based on their duties.
I absolutely do. And as jobs change over time, responsibilities change, this is an excellent opportunity for employers to sit down and evaluate whether or not their job descriptions match the work that's being performed. Has the work in the position evolved over time? Are there some positions who fall within a gray area from a duties perspective? It's a difficult thing to make this kind of shift when you're not in a place where there have been proposed regulation changes, and sometimes people can be a little frustrated about being moved back and forth from exempt to non-exempt status. But evaluating those duties tests at this juncture, with the opportunity to also evaluate with the coming with these changes that have been proposed by the DOL, I think can both mitigate risk for employers and can also make the message a little more palatable for employees when you're making that decision.
Yeah, I think, we're going to talk about in a moment what employers need to do and what they don't need to do currently. But I think your point is a significant one, and I want to emphasize that. I think what you're saying is, some employers may choose to take workers that are currently classified as exempt and change their classification to non-exempt. I think what you're saying is some employees won't like that. Is that right?
I think there's a chance that is absolutely the case.
Yeah. And so this gives you a little bit of cover for when you're changing the classification of someone who might not meet the duties test anymore, or it's gray that they're meeting that duties test. This new regulation and the pay thresholds may give you some cover to make changes that needed to be made anyway.
Absolutely.
Okay, so interesting point that the DOL makes in the introduction on the new rule. The DOL actually expressly states that raising these salary thresholds in the significant way that they have, making these salary thresholds higher, is really, as the DOL puts it, an advantage for employers, even though it would arguably raise salary costs significantly. The DOL says that this new regulation with these new salary thresholds will reduce the burden on employers because employers won't have to worry about those long, complicated duties tests. If we're not paying employees at a high enough threshold, then we don't have to worry about those 7 concepts and their long definitions, effectively making salary level the only part of the test in a lot of cases, the only thing that matters. And that's really, really important because, as you all know, if you've been in the HR professionals business for the last 5 or so years, this particular rule is very likely headed for litigation. So, Natalie, we've done this before, right? I mean, tell us about 2016 and what happened under President Obama right before an election, just like we face now.
So in 2016, President Obama's administration promulgated some similar rules where we saw them doubling the minimum weekly salary for white-collar employees in those proposed regulations. When they took effect, almost instantaneously in November of 2016, the rule was challenged in federal court, and a federal judge in Texas entered a temporary injunction prohibiting the rule from taking effect. In 2017, that same judge entered summary judgment, holding that proposed rule should be invalid. The court ruled that the DOL setting such a high salary threshold for white-collar exemptions was beyond the statutory authority that's granted to the DOL under the FLSA. And the truth is, the FLSA doesn't make any mention of a salary basis test at all. It is all a creature of legislation that the DOL crafted. And so the question becomes, should the focus really be on the duties test as opposed to essentially eliminating its necessity by continuing to ratchet up that salary basis?
Yeah, and so the court in that particular case, I thought it was a really interesting ruling at the end of the day. The court ultimately said, the statute that Congress actually passed, the Fair Labor Standards Act, really focused on the duties of employees. It focused on making an exemption for employees that performed executive, administrative, or professional duties. And the Department of Labor's focus on a salary basis and using a salary basis to effectively eliminate a look at those individual duties was improper, according to the court. The court said that exceeds the authority that the Fair Labor Standards Act provides to the executive agency, the Department of Labor, within which it can rule. And so it's an interesting conclusion, mainly because that's exactly what we have now.
Yeah, despite that big, long introduction, that is expressly what they've done here once again.
Exactly. And so And what's interesting now is as we undoubtedly are about to see similar litigation filed by similar groups, chambers of commerce and otherwise, to try to challenge the new salary threshold regulations. Since then, we have seen a couple of comments from the United States Supreme Court even. And so why don't you tell our viewers about Justice Kavanaugh's comments in the Helix case?
So in that case, that in a dissent, Justice Kavanaugh held that the act focuses on duties and is not how much an employee is paid. So he believes it's really questionable as to whether or not these departmental regulations are going to survive when they're challenged, because they are inconsistent with the act. They develop and essentially establish a whole nother level of analysis that the act never contemplated.
Yeah, and so it's interesting because even though that case wasn't really about the DOL regulations, and even though it was a dissent, it probably arms whichever federal judge takes up this issue with kind of additional support, with the idea that maybe the United States Supreme Court would back a district court's decision to criticize these regulations. So it's very unclear what's going to happen to these regulations between now and July 1st. And that brings us back to kind of the most important comment of the day, which is, what do employers do now? We've got a set of regulations in place that tells us that starting in July 1 and again on January 1, the threshold to have an exempt employee is going up, and it's going up significantly. We're telling our viewers that there may be litigation and those may get put on hold, but what do employers need to do? We're in this limbo state right now. We don't know exactly what's going to happen with these regs. What should our employer clients be doing right now?
Well, so many of us back in 2016 jumped the gun, and a lot of adjustments were made to the economics of employees' compensation levels based on the regulations that were released. The reality is that those did not take effect, and it's very difficult to roll back those kinds of increases. And so what we're telling our employers, and what we're advising them, is to be cautious, right? We know and expect that there will be legal challenge here. We can't be unprepared, which means we need to sit down and do the work of evaluating those positions that fall in the gray area, that are not within the salary threshold levels, that are between those numbers. And we've got to do that on a 2-level basis, right? Because we've got potentially a level to satisfy in July and again in January. But we should make decisions preemptively about whether or not we're going to make adjustments to compensation. And if we are, we've got a budget for those, and we can be prepared for that. We should also be prepared for the fact that if we do have to make these changes, we're going to have to train some of our workforce who hasn't been keeping time for many, many years, perhaps, that they're going to have to do that. But we think you should do all of that homework. We think those spreadsheets should be ready. We think the analysis should be done, but we'll caution you from actually pushing the go on that until we see that these regulations are not going to face defeat as quickly as they did in 2016, so that we don't implement a significant number of pay increases that are not going to actually ultimately be legally required.
Okay. And so we're going to really look at two things. Number one, with respect to your exempt employees right now, do you need to raise their pay?
Right.
Number two, would you rather just classify them as non-exempt going forward? And then for those individual employees that you are going to keep as exempt going forward, probably, again, as we talked about a moment ago, good opportunity to look at those duties tests and make sure that regardless of what we're paying them, we're properly classifying those people.
As you're sitting and going through those lists where you find those folks in the gap, and even those who don't, it's a good opportunity to take a look at those job descriptions and to make an evaluation based on those duties tests as well, because it is, again, as you had mentioned before, it's an excellent cover for us to make adjustments that are applicable to multi-levels of this test.
Okay. So I think that covers everything that we wanted to discuss with you today. There will definitely be more news with respect to these regulations, and you're probably going to need some help in implementing those regulations. So we stand ready, willing, and able to help you through it. We will certainly be monitoring the issue going forward. And as we learn more about potential litigation and the likelihood of these regulations actually going into effect, we will certainly update you as soon as we know. And as always, we thank you for tuning in, and we'll talk to you again soon. Thank you.